therefore, my clients, by that standard, could be videotaping from 100 feet away, or no, sorry, not 100 feet, videotaping from 25 feet away, and the city could claim a violation. So all we're ending up with then is an argument over, harassment, intimidating, whatever, and I would, again, it just violates, in my mind, all the standards of what an injunction should look like. Now, the city has said basically, well, don't look at this so much. Do put together your own proposal. And I guess that really goes to the final, most important point in this case, which the city has completely misconceived of the proper role of this court. The city is basically asking this court to set the rules, to create the rules, to establish the rules. And that's not the appropriate place for the judicial function. There is, this is not a matter, if the court denies the injunction, it's not like anything goes. I mean, there's already criminal ordinances, criminal statutes that restrict demonstrators. There are civil laws that restrict demonstrators. There are city ordinances that restrict demonstrators. And if the city thinks that individually or cumulatively those restrictions are insufficient to protect the parking enforcement officers, then the city has the option of putting together a new ordinance. And the difference between the city going through the city council and putting together a new ordinance versus coming to the court and asking the court to create one is fundamental. It's fundamental in two ways. First of all, when the city promulgates an ordinance, then anybody who believes it's illegal has a right to challenge it. And then the court sits in its appropriate place as a reviewing body, not as the creating body. So there's a delineation between the legislative and judiciary. But the second difference is that if the city creates the ordinance, it has to be a general application. It's not just limited to 6 people, or not just limited to one group. It's a general, it has to be a general application. And that's essentially when you're dealing with constitutional rights. If there are going to be restrictions, they have to be generally across the board, not specifically tailored to deal with one group of demonstrators. So, if in fact there is a need on the part of the parking enforcement officers to some type of protection, which again certainly hasn't been supported by the record, but if there were such a need, the city has fundamentally gone about it in the wrong way and has put the court in the wrong position. And again, my clients have an obligation to comply with the law. And there's been no argument that they haven't complied with the law. But they shouldn't be subject to special restrictions, sort of created especially for the purpose of this case, because the city's not happy with that political actions. Thank you.
Hang on, briefly.
One thing that can be gleaned from the testimony and the arguments is that the city of Keene does not object to the motivations or the conduct of the defendants as long as it does not interfere with the governmental interests of carrying out their jobs. That's the one disconnect that the defendants and my brother failed to address. That there is a right to protect employment interests, and the Constitution does not trump that right. And this is the appropriate forum to address that issue, because injunction would be tailored and not so broad as to affect everybody under all circumstances. The evidence that you've heard, and you've heard evidence with regard to 6 individuals. Some have been more intrusive than others, I grant. But not everyone has, not everyone would be enjoined from this injunction. We've heard testimony in this case that there are other people, and I think you've seen some photographs, that there are other people who are also intrusive. This injunction would not run to those folks. But I suggest that the message that would be sent by this court would be that that conduct of interfering and taunting and harassing, and in one case causing one employee to believe it was intolerable to work under those circumstances anymore, believe that the message would get out. And I think that the precedent, if this court were not to issue an injunction, the precedential value of that would be horrendous. There would be free reign on the streets of Keene. And what we're asking this court, and you specifically, is to balance interests, not only of these folks here, and not only of those folks there, and not only of the city folks, the interests, but also the community. You've heard that there have been engagements by citizens stepping between these folks. It's gone on too long. We came into court in May. We didn't rush into court. We did our homework. We came in May, and unfortunately we're in September. And yes, there has been one casualty. And just because there has been one casualty, I'm sorry to say, Alan, does not mean that there is an adequate remedy of law. Perhaps for the cost that you've heard from the finance director with regard to his replacement and Jane's covering of different work, but there's going to be another employee. And there's going to be Lynn, who we heard from a long time ago. She's in the balance, so her interests and the city's interest in Lynn need protection through an injunction. The last thing I'll say, because now I think we're starting to repeat ourselves, and that is this. The defendants can do all of the things within a reasonable distance back pursuant to your injunction. They can videotape. They can have discourse. They can get their message out. And they can do all those things, and these folks and other folks like them, Department of Public Works employees, anybody else who has an office, you know, we're the lucky ones. We have an office in the buildings. So we have restrictions placed on First Amendment. We have restrictions downstairs where you can't bring in guns. We have restrictions for clerks of court and bailiffs. These folks don't have those restrictions. They don't have law enforcement responsibilities or authority. And we're asking that a reasonably crafted, fashioned injunction be put in place that will be abided by both sides. Thank you.
Thank you both very much. Let me say that I'm glad we had the time this afternoon for our argument. These are important issues. I recognize that these are important issues to the city of Keene and the employees, and I also recognize these are important issues for the defendants. I can assure counsel and everyone that I will give consideration to all the arguments and give this a lot of thought. And I know the council are going to submit additional memoranda next Wednesday. I'll read them thoroughly, and once I've done that, I'll issue a decision in this case. And I appreciate the time and effort and frankly the skill that council have shown in not only arguments this afternoon, but also in the presentation of the case. I think it was well presented by both sides. Thank you all very much. Harry Meyer,
Can I
yes.
just request that in terms of deadline for memorandum, maybe we like a smart date so we don't have to bother to have to drive it.
Yeah, not a problem. Let me say if why don't I just say that memoranda will be submitted to the court by next Friday. That in the ordinary course,
Thank you.
Again, you have experienced counsel. If somebody runs into an issue and you need additional time, you both work very well together in terms of scheduling issues. Just communicate with the clerk's office. I doubt it'd have any problem with that, but we'll make the deadline next Friday.
And can we just work with the court? We have our citizens.
Absolutely.
Thank you.
Yeah, I just to deal with the exhibit issues. Thank
Thank
you
you.
very much.
All rise, please.
He heard the arguments for it. They have until next Friday to issue a further memorandum of law. After he reads those, he will issue a decision. Generally, I'm guessing it'll probably be beginning of November. Generally, it's like 30 days after.
Yeah.
Yeah, I could do that.
No.
What sort of excitement do they have you covering after this?
Yeah, we're working on this tomorrow morning. And then something completely different. We're trying to schedule some off Thursday, Friday. This place up in Walpole called Rice Mountain Estates. It's
Never heard of
incredible,
it.
man. It's
Thanks, dude. No, yeah, it's on.
incredible.
It's about 10 minutes on this battery.